Every day in the USA, people find themselves in court.
23 CR 1460 is called the State of Texas versus Rogelio Herrera. That's you?
Yes, sir.
Present with Mr. Grove, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment alleges that on or about August 30th, 2023, in Jefferson County, Texas, you committed the third-degree felony of assault on a pregnant person. Well, that's terrible. That's terrible. You make it a practice of beating up on girls, or is that who you beat up on, or do you ever try men? But what do you think about beating up on a girl?
Looking good, sir.
No, it's about as low as it gets. It's like beating up on a child, isn't it?
Yes, sir.
Is that the kind of person you are?
No, sir.
The grand jury said you are. They indicted you for this. That's pretty low. Generally, people who pick on others, their gender and size, the ones who pick on others other than their gender and size, generally are cowards about picking on people who are their own gender and their size. Are you a coward?
Yes, sir.
Why would you assault a pregnant woman?
It was a misunderstanding, wasn't it?
Yes, sir.
Oh, you didn't know she was pregnant?
No, I knew.
Really? Well, there's two life forms there. Are you nodding? Does that mean yes? Can you speak English?
Yes, sir.
I see there's an agreement that's been reached where he would be pleading guilty to a lesser class A misdemeanor. Sell that to me, please, under these circumstances. I don't think it's morally right, but what do y'all want to say?
That's primarily based on my communication with the victim of this case, Judge.
And I've had similar communications, I believe, with the victim, although I did not overhear any of Mr. Ham's, but
She's
she
the
requested.
one that talked me into it, Judge.
She's been adamant that she didn't want to prosecute.
Well, that's not what probable cause affidavit says. Are you telling me at the time of the event, she insisted not to file?
Oh, no, sir. That's not where she was.
That's what
Judge.
you just said.
That was what she told me when we spoke over the telephone. Yes, Your Honor.
Okay, after he'd been in jail and had communications with her, which you're not supposed to have.
No, I didn't have no communication with her, sir.
Judge, I'm the one that's approved this agreement. The reason why I have is he doesn't show to have any record as far as that's concerned. This agreement with the conviction will allow, if he does anything further like this, it will result automatically in a felony, and it abides by the victim's wishes in this regard.
Well, all of us know what the statistics, science shows. in this type of behavior. Once you cross the line, you're capable of doing it, and you've shown a propensity, and that generally is women are vulnerable to this person. And I just get the sense he couldn't care less. I just get the sense that beating up on girls, pregnant women, are just the kind of thing that he does. What a thug. See, got into a verbal argument over a cell phone code. That's all it takes for you to beat up on a pregnant person? Something meaningless like that. You punched her in the head with a closed fist, causing injury to her. Later, y'all began arguing again. You threw a multivitamin bottle at her leg, causing a bruise on her right leg. The agreement here is that you would be sentenced to 1 year in the county jail pursuant to the lesser included offense of Class A misdemeanor assault. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily to this Class A misdemeanor? And
Yes, sir.
because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Did you understand it, discussed it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence
No objection.
without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. So help you God. Is that so?
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes without objection.
No objection.
It's admitted. Do I make a finding that this involves family violence?
You can, yes, sir.
I know I can. Is that,
It's appropriate under these facts, circumstances.
That was not part of our agreement, Your Honor, but I'm not going to object to that.
but does it fit the definition of family violence?
It does, because the relation, it's a boyfriend-girlfriend relationship and he's the expected father.
Right. Okay. There's not an objection to that, correct? You can speak out.
Yes, sir.
Okay. If nothing, battery's low. So you were pleading guilty today voluntarily. You were mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1. Admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this Class A misdemeanor involving family assault. You are hereby sentenced to confinement in the county jail for 1 year. The judgment shall reflect that this involves a case of family violence, and it will be rendered in the judgment in this case. Do you understand what has happened today, sir?
Yes, sir.
And that is your child.
Yes, sir.
Legally and morally, you should treat your child's mother decently. Whether you believe that or not, that's a moral. That is.